So good morning, everybody. Welcome to our webinar on AI and litigation this morning. Thank you for joining us. My name is Joanna Wilkinson and I'm a Senior Associate Solicitor in the Commercial Dispute Resolution team here at Irwin Mitchell. I'm joined this morning by my colleague Ross Condy, who's a solicitor in the team. Our contact details are up there on the slides now. So Ross and I have a specialist interest in disputes arising from technology and artificial intelligence, but also how those tools can be used to assist us in doing our day-to-day job. And we'll share some insights with you today on that. So first things first, the webinar is being recorded. A copy of the slides will be circulated after the event. There's also a QR code on the next slide, which takes you to our feedback survey. And we'd be really grateful if you could take a couple of minutes just to provide us with any feedback so we can then shape future sessions for you. So this webinar is the first in a series of webinars, which will be hosted over the next 8 months or so by our expert commercial dispute team, and we'll cover a range of different topics within those webinars. The series is in support of a campaign we're running in partnership with the lawyer, which will launch early in the new year. And that campaign focuses on strategic insights on the current climate and how in-house legal teams are facing mounting litigation risks. So we'll be holding a number of fringe events in the new year across our main offices as well. So please keep an eye out for those on LinkedIn, or let us know separately if you'd like to receive information about those events when they go into the diary. Details of the webinar series are available on the final slide. So we'll also provide details of those separately as well when we circulate the slides from today. So we should have some time for questions at the end, so please pop any of the questions you have in the Q&A section in the platform. But in terms of what we'll focus on today, we'll be looking at how AI is currently being used by litigators, where AI is causing problems, some personal insight on experiences that we've come across within our team, some sector guidance on the use of AI, pointers on mitigating risks, how we can shape AI, how we see AI shaping the future of litigation, and then some key takeaways. So there's quite a lot to get through, but as is usual with these types of webinars, the information that's contained in the presentation doesn't constitute legal advice or other professional advice, or seek to be an exhaustive statement of the law. So if there's any specific legal advice that you do need, please seek that. So let's start with the basics then. What is artificial intelligence? Obviously the term AI is everywhere and most people will use it or hear it on a daily basis. So in general terms, artificial intelligence is technology that enables computers and machines to simulate human learning, comprehension, problem solving, decision making, creativity and autonomy. So the type of AI that we'll be concentrating on today is generative AI. So we're talking about large language models, and these are trained on huge amounts of data and use algorithms to predict word sequences to generate answers. So just starting with a couple of statistics. So AI adoption is accelerating across the board in terms of its use within the legal sector, but also the wider economy, with most, if not all sectors now integrating at least some form of AI into their daily processes. So based on the artificial intelligence sector study from 2024, which was undertaken by the Government Department for Science, Innovation and Technology, at that time, there were around 5,800 AI companies in the UK's AI ecosystem, and that was an increase of 85% in the previous 2 years. I'm sure it's even more now, and that really is pretty incredible and shows the trajectory of how AI companies is going. And then looking more closely at the legal sector, 44% of corporate legal departments are using legal-based AI technology, either frequently or all the time. And AI integration is found to be better in larger law firms than those with less than 4 partners. So how do we use AI currently? So in litigation more widely, we're seeing an increased number of litigants in person bringing or defending claims. And I think that's because they feel bolstered to use AI, and because they are using the AI, they don't then feel that they need to instruct separate legal representation. That, of course, is an advantage to the litigant in person. It reduces cost and time. However, because the litigants are generally using ChatGPT or similar open online AI tools, these are trained using unfiltered content, so they're often producing inaccurate results, which the litigants are relying on, and then it's creating additional work for us as lawyers, just because, you know, as a starting point, we've got to decipher what the litigant is actually trying to say. As litigators, we're using AI quite regularly. So most commonly, we're using it to assist us in drafting tasks such as letters and court forms. Obviously, heavily caveating that with the fact that we always double check what the output of that AI is before we rely on it, but it serves as a good starting point. We're also using it to extract information from documents, so summarising lengthy judgments or pleadings, or preparing chronologies from a bundle of initial documents. As you can imagine, if we've a lengthy judgment, just being able to pull out quite quickly the key points and arguments, it just makes us better placed to understand the main concepts before we then get into the detail. We're also using it for research tasks and assisting fee earners with the disclosure process when it comes to disclosing documents. And I'm going to pass over to Ross now, who will consider the use of AI in disclosure in a bit more detail.
Thank you, Joe, and hello, everybody. Yeah, as Joe touched on there, disclosure is really an area where the legal sector have really progressed the use of AI, and it's even been endorsed by the courts, which we'll touch on today. So for those of you who don't know, or you may have forgotten, disclosure is the process where parties are required to share relevant information, which might be helpful or it might be harmful to their case, with the other side of the dispute before trial. And in complex commercial cases, which is what we're used to dealing with, this involves vast amount of documents, and therefore teams of lawyers making decisions about whether those documents are relevant, privileged, or otherwise. So technology and AI are well placed to help with this disclosure exercise because mostly because they're very good at reviewing vast amounts of documents in much less time than a human's able to. And of course, that intelligence aspect of the AI has the ability to learn. And this has meant that there's been the development of what's known as technology assisted review, so TAR. And that's where lawyers review a sample of documents, they mark them as relevant or not, or privileged. The TAR software learns from those decisions and applies that to a wider pool of documents, and that might be thousands, it might be hundreds of thousands of documents, and it can do this in much shorter time than a human can. And the courts, and as you can see on the slide there, this is not just something that lawyers are adopting, but it's been endorsed by the courts, and that stems from the two key cases there on the slide. So that's Puro Investments, where the use of TAR was found to be proportionate and accurate for large data sets, and the Brown case, where the court ordered predictive coding despite objection, as it was considered considerably cheaper and just as effective. So these decisions really underwrite today's AI-assisted disclosure practices that we as lawyers are all used to. And they've even been embedded in the court rules. So Practice Direction 57 AD, the lawyers or the commercial lawyers on the call may be familiar with this. It's the court rules that govern disclosure in the commercial court. And within that practice direction, there's an express duty to liaise and cooperate with the other parties to promote the efficient conduct of disclosure. And that includes the use of technology. In the disclosure review document, which was a key part of the disclosure process under these rules, the parties are required to consider the use of technology and how it can facilitate the collection of data and document review. And specifically noted in that document is consideration of the use of technology assisted review, which I referred to earlier. Where parties aren't using it, they're required to explain that to court, especially if there's a large amount of documents which might be very expensive to otherwise review. So here, AI is being embedded into the court processes, and it's well established now. So, you know, AI is extraordinarily powerful. Its use is widespread and growing, as Joe alluded to, and elements are being endorsed and encouraged by the court. So, what's the issue then? Well, as you might expect, things aren't so simple. If we can move to the next slide, Lisa. The first issue that we're going to touch on today to be wary of is an issue that many of you might have already heard of, and that's hallucinations. So what are hallucinations for those of you who don't know? So it's where an AI system generates information that is factually incorrect. In fact, it may be entirely fabricated, but it can sound incredibly plausible. And AI is want to do can be very confident in giving that answer. And it's a known limitation of large language models that which many of us will be used to using, but it's a real risk in a legal context where, as many of you will know, accuracy and truth is so central to what we do. Yet, legal professionals are using these tools and getting it wrong. And we're going to just explore a little bit of case law where this has been an issue and exemplified the issue. It's not only vital to your commercial interest, but it's a matter of ethics and a regulatory issue for lawyers as well. So it's incredibly important. And if we can just move to the next slide, Lisa, we're going to touch on a couple of cases that sort of underscore these issues, and some of the lawyers on the call may be familiar with them. It's the Ayindi case and also the Al Haroon and Qatar National Bank case, which were both heard together in divisional court. And they serve as a real warning and have led to further guidance on this issue. So in the Ayindi case, there was a claimant which challenged Haringey Council's refusal to grant him interim accommodation. But most importantly for our purposes, it emerged that the claimant's legal team had cited 5 fictitious cases in their pleadings. These were presented of authoritative precedents, but ultimately they didn't exist. The opposing party picked up on this, and they suggested that it was due to the use of artificial intelligence. But there wasn't evidence submitted in this regard, and so the judge in this case, Mr. Justice Ritchie, declined to give a finding on whether AI had been used. But in determining the cost of the case, the judge did consider that that had been improper conduct because, frankly, the case references were false. And he went so far as to describe this as appalling professional misbehavior. And described it as improper, unreasonable, and negligent. And the result was issuing a wasted costs order against the claimant's legal representatives. So this raised serious concerns about the use of generative AI in legal proceedings and the risk of producing false citations. And it's resulted in a broader judicial reflection on the use of AI in legal drafting. And at the Al Haroon case, it was similar issues arose there. It was where a solicitor submitted a witness statement containing false legal references. Again, there was a suspected use of AI, but no finding on whether AI had been used there. And if we move on to the next slide, Lisa. So just to briefly touch on why the legal representatives got this wrong. Well, there were some excuses given. For instance, in the Ayindi case, counsel for the relevant party argued that they had a lack of experience, lack of supervision, and they had some challenging personal experience that mitigated the circumstances. And the instructing solicitors said that they lacked the resources for proper oversight. In the Al Haroon case, they admitted failing to verify the relevant submissions, but they said that they were unaware that the citations had been fabricated. If we move on to the next slide, Lisa. So what did the court say? So The court found that there was a lack of proper diligence in this case and professional oversight, and using these fake citations breached the lawyer's core duties of professional standards, including honesty and integrity. And the lawyers on the court will know how central honesty is to our duties as lawyers. So the explanations that were given by the relevant parties were rejected, and the claims that these issues were minor issues was also rejected. Because on the basis that the court process was considered to be compromised. The court did acknowledge that AI tools can be used if cautiously, but and this is central to and a key point that we're trying to get across today. They require verification. They simply can't work without oversight at this stage. And this has led to guidance, which we'll touch on later, given to judges about the use of AI. So if we could just move on to the next slide, Lisa. Just to look at what the result was. So contempt proceedings, which many of you know are very serious, were not initiated, but the relevant lawyers were referred to their respective regulators. And some key takeaways here are that, AI, while it offers efficiency, it must be used with rigorous oversight. And the courts have made it clear that professional standards apply fully to the integrity of these submissions. So the point is that, having knowledge of the law is not enough. These AI tools are incredibly convincing in the way that they present false information. So lawyers need to make sure that they're using the right tools in the right way with the appropriate oversight at all times. If we can move on to the next slide, Lisa, there's another more recent case that we're just going to touch on here to emphasize the point. And this is Bandler and the SRA, where Mr. Bandler, he was a practitioner which had been struck off because he'd failed to tell the SRA that he didn't have insurance cover for or had falsely told the SRA that he had insurance cover for a specific period. And he abandoned his practice. And he didn't appear at the relevant disciplinary tribunal, but he later sought to appeal the strike-off decision. He claimed that during the period where he was said to have abandoned his practice and wasn't responding to the SRA, that he'd been suffering from severe schizophrenia, and so he wasn't able to understand or even really communicate at that time. The judge considered that there were gaps in the evidence submitted in relation to his mental health, but what was made significantly worse in his appeal submissions, and is important for our purposes, is that his grounds of appeal cited 25 non-existing cases. So if we can move to the next slide, Lisa, and just consider what the court thought about that. Mr. Bandler, he denied that this use from the arose from the use of AI. And again, there was no specific finding from the court on the fact of whether AI was used. But the grounds of appeal were struck out as an abusive process. And it was considered that it was important for the court to take decisive action in order to protect the integrity of the court's process. And you can see on the slide a quote from Mr. Justice Fordham in the case. Again, he's talking about the integrity of the process, which the court clearly holds so dear. And if we move on to the next slide, Lisa, in terms of why the appellant, Mr. Bandler, said he used non-existent authorities, or why that might justify his appeal not being struck out, he responded to say the substance of what he was arguing was legally sound, even if the authority he cited didn't exist. But the court rejected this, and it's quite an important point that it doesn't necessarily matter if your arguments are right. If what you've included is false, then it's a very serious matter, which in this case resulted as was deemed an abusive process, and therefore his appeal was struck out. So this case should serve as a stark warning. Hallucinations are a real risk when using a generative AI to produce these types of documents, and making submissions without proper oversight and verification can lead to, an abusive process and result in striking out of submissions, as was the case with Mr. Bandler. It can lead to cost consequences for the lawyers and their clients, and it can also lead to disciplinary issues. So it's an incredibly serious thing to consider when preparing your submissions. So I'm just going to pass back over to Joe to talk about IM's own experiences in dealing with some falsely cited cases.
Thanks, Ross. So, yeah, as you can see, there are a number of cases starting to come through the courts now whereby practitioners are being caught out by using generative AI to highlight supportive authorities, which simply just don't exist. And it's incredible, really, that there are already so many examples of trained practitioners making these fundamental errors, and it just really emphasises the fact that human verification is key when using any AI tool. And the cases that Ross has just referred to also highlight the possible outcomes and orders which could be sought should you find yourself on the receiving end of correspondence or a court claim which relies on hallucinated cases. So it's definitely worth bearing those in mind. Interestingly, we have had a couple of instances within our team whereby both litigants in person, one of which was actually a practicing solicitor, and a law firm have cited authorities in correspondence which were completely made up. So the matter, which involves the practicing solicitor, actually included 3 hallucinated cases in their statement of case. So when we were preparing the defence, we obviously started to look up these cases and struggling to find anything on Westlaw or Lexis, and it quickly became apparent that the cases as cited didn't actually exist. So in the first instance, we asked the claimant for copies of the judgment or case summaries to assist us, but they refused on the basis that they didn't want to do our job for us, which was rather unhelpful. So we then involved our research team, and they prepared a report setting out the detailed search methodology, which we'd had to implement to trace the 3 cited cases, or to try and trace them. And the methodology was based on 5 individual search components. So those were searching for the reference or citation, searching for the case name as a whole, but then also separately searching for just the claimant name and just the defendant name, and then the date of the judgment with the court that had been cited. So that report set out the sources that we used, and these were a mixture of subscription databases and freely available sources, with preference being given to the more authoritative subscription sources, so Lexis and Westlaw. So this level of detail was required to demonstrate to the court why we were unable to respond to the specific allegations made in the particulars of claim, which relied on the hallucinated cases. And it's a brilliant example in real time of the additional time and resource which we had to spend as a result of AI getting it wrong, but also how far you need to go to demonstrate to the court the likelihood that the cases had in fact been hallucinated by an AI tool. So in the examples we've considered, again, just pushing home the point, most of these errors could have been avoided had the user verified the content which the AI tool had produced, and it's just bringing it back to that point that human verification must also be applied when considering any AI output. So just moving on to the next slide, please. We've covered some examples of how the courts are dealing with cases whereby parties are introducing fictitious authorities, but you also need to be aware of how you or your businesses, acting either a supplier or user of services, could also be caught out. So we're seeing increasing problems arising within businesses due to the lack of complete control and predictability of the output of generative AI, for example, where the AI hallucinates or produces inaccurate responses. This may lead to breach of contract, which in turn is leading to issues regarding the apportionment of liability across the AI supply chain. So an example of a case which highlights these issues in practice is Leeway Services and Amazon Payments. And so the key facts of this case were that Leeway Services operated as a third-party seller on Amazon's UK marketplace. And in June 2021, its account was suspended, which Leeway claimed was due to automated decision-making systems, which included AI, used by Amazon to monitor compliance and detect risk. The suspension prevented Leeway from making expected online sales during a peak trading period. So Leeway argued that Amazon's reliance on the automated systems, again, which included AI, led to an unjustified suspension, breaching contractual obligations and causing significant financial loss to Leeway. And the claim raised questions about who's responsible for algorithmic decisions and whether Amazon exercised adequate human oversight. The dispute focused on the Amazon Services Business Solutions Agreement and the related payment terms. And the issues included whether Amazon had reasonable grounds under the contract to suspend the account and whether its process complied with implied duties of good faith and fair dealing. So it's not an intellectual property or data protection case, but it did highlight commercial risk from automated enforcement and the lack of transparency and human oversight in AI-driven compliance systems. So the case was issued in June 21 and is widely cited as an example of early UK litigation involving AI-related decision-making in commercial platforms. The public sources that are available suggest that the matter actually settled before trial, so there's no reported judgment, but it does remain a reference point for contractual disputes linked to AI automation. And I think the key takeaway from this matter is that it's really important to consider the contractual position and be transparent about your use of AI in decision-making processes and communicate those to any user. And as a user, you need to be making sure that the supplier is transparent on the processes that they're actually using. I mean, there's numerous sub-issues relating to data protection and the processing of data, which can sit outside the scope of today's webinar, but where possible, contracts should deal with the apportionment of liability and also include express dispute resolution clauses, just so there's some kind of fallback to assist if issues do occur. So I'll pass back on to Ross now, who'll touch on some of the considerations to be had when dealing with consumers.
Thank you, Jo. Yeah, so for consumer-facing businesses, there's additional risks of using AI and potential avenues for claims by consumers that companies should be aware of. Now, these issues stem from some of the issues which we've touched on. So the misleading outputs that can be generated by AI tools. So, for instance, that might be professionals relying on a generative AI to produce advice or documents which contain false or misleading information. And if that results in financial loss to a consumer, then there's a risk to the company. Again, AI can be used and is widely used for sort of automated contract drafting. There's potential issues there if the AI sort of misstates the terms of the contract or includes omissions or there's ambiguities within the contract. And then there's also an issue in relation to misrepresentation in consumer communications, where the business is using AI to interact directly with consumers. So I'm sure we've all used chatbots when communicating with businesses. Those are often backed by AI, and if those chatbots use misleading claims that result to a loss, again, there may be a risk to the company. So I'm just going to touch briefly on the law of negligence, because there's a question mark here about how the law of negligence applies to AI, and whether AI is sort of stretching the boundaries of the legal definitions of negligence. For instance, consider a couple of issues here in relation to key elements of a negligence claim. So firstly, in relation to causation. So if AI was responsible or was used in part of the process which caused a loss to a consumer, who's responsible for that loss? Is it possible to establish factual and legal causation in relation to outputs of an AI? And are any harms reasonably foreseeable where AI systems can produce unpredictable, autonomous, and differing responses? So, Lisa, if you wouldn't mind moving to the next slide, we're just going to consider a case. It's a Canadian case, so it's not binding on the UK courts. But it's an interesting one for you to consider, because it involves a consumer-facing business and certain issues in relation to negligence. So what were the facts? So this related to, it was Moffat and Air Canada. Mr. Moffat booked flights with Air Canada after the death of one of his relatives. After doing some research about fares, he used the Air Canada's chatbot, which advised that he could apply for a bereavement fare, so that's a type of discount, and that discount could be applied retrospectively after the tickets have been issued. The chatbot did also send a link which included the right information on their website, which said that you couldn't apply for this type of discount retrospectively. But Mr. Moffat relied on what the chatbot itself had told him, booked his flights, later applied for the refund or partial refund, and he was denied the refund on the basis that he couldn't apply for it retrospectively. So he brought a claim, and he was seeking the difference between the difference between the fare that he paid and what he would have paid had he benefited from the bereavement discount. So we move to the next slide, Lisa. I'm just going to briefly consider what the court needed to consider in the circumstance, because Mr. Moffat was claiming that Air Canada was liable for negligent misrepresentation by its chatbot. So the court considered the duty of care. Did Canada owe Mr. Moffat a duty of care as a consumer? Was there misrepresentation? So what the chatbot said untrue and inaccurate and therefore misleading? Was the misrepresentation made negligently? Did Mr. Moffat rely on that advice, and did he suffer a loss as a result? So Air Canada argued that the chatbot itself was a separate legal entity, and therefore Air Canada should be held liable for the statements of the chatbot. And if we move on to the next slide, Lisa, we can see that the tribunal rejected that argument, effectively suggesting that the chatbot was part of Air Canada's website. So just as the company may be responsible for the information it puts on its website, it can also be responsible for what its chatbot said. And therefore, it found that Air Canada did owe a duty of care to Mr. Moffat, and it failed to take reasonable steps to ensure that the chatbot was accurate. Despite the fact that there was a link to the accurate information, it was deemed that Mr. Moffat's reliance was reasonable, and as a result, he was awarded damages. So while not binding on the UK courts, it's an interesting case and something certainly for consumer-facing businesses to be aware of, where they're using chatbots, that it's possible that the law of negligence can be applied to hold you responsible for the output of those chatbots where consumers cause loss as a result. So it just maintains the importance of maintaining your AI chatbots, making sure that they are up to date and their outputs up to date, and ensuring policies and consistency throughout your use of these tools. So I'm going to hand back over to Jo now to talk a little bit about the IP law in this area.
Thanks, Ross. Just touching on what you said there, I just find it really interesting just how there's the interplay between AI and then the legal obligations that are owed, and there's going to be so many other examples of those types of cases coming through, I've no doubt. And we, as Ross said, we just wanted to touch briefly now on some of the issues that arise in relation to intellectual property. Again, this is another huge area where AI is causing mischief. So whilst Erwin Mitchell's IP specialism kind of sits outside of our team, it certainly would be remiss for us not to make reference to some of the IP issues that exist in relation to AI. So firstly, the copyright in the training data. So generative AI models require vast data sets, so they're often include copyrighted works such as images, text, music, and right holders or the holders of the copyright argue that using their works for training the AI models without consent infringes the copyright in that work. There's also issues around the authorship and ownership of AI generated works. So traditional copyright law assumes a human author, and obviously AI generated content kind of challenges that principle. So no doubt that there'll be further exploration of this position in the future. In respect of patentability of AI and AI-driven invention, there's a question mark around whether or not AI systems or neural networks themselves can be patented. AI can obviously replicate brand indicators, so is the infringement of watermarks, trademarks, potential patent off claims. That's a huge area within intellectual property and the interplay with AI. And also lastly, in respect of database rights holders are arguing that curated data sets qualify for unique database protection, and that's one of the matters that was considered in this next case that we're going to touch on, and it's a judgment that was handed down just last week, and it's one of the most significant UK intellectual property disputes involving generative AI, and that was the case of Getty Images against Stability AI. So Getty Images sued Stability AI over its image generation system, which they called Stable Diffusion, and Getty alleged that the model was trained on millions of Getty's copyrighted images without their permission, and that the output sometimes reproduced Getty's watermarked content. So why is this case important? I mean, the trial spotlighted a number of unresolved issues. Firstly, does training an AI model on copyrighted works constitute infringement under UK law? Can an AI model itself be treated as an infringing copy, so not just the output that it produces? And how should courts balance copyright protection with innovation in AI development? So in respect of allegations or the allegations around copyright infringement, Getty argued that using its images to train Stable Diffusion amounted to copying protected works under UK copyright law, and Getty claimed that images generated by users through Stable Diffusion could reproduce substantial parts of its work, making those outputs infringing. And the central question was whether or not the data used to train the AI model itself could be treated as an infringing copy for the purposes of the Copyright Designs and Patents Act 1988. Stability AI obviously maintained that the training of the AI model occurred outside of the UK, so that UK copyright law shouldn't apply. And this then raised complex questions around territorial scope and cloud-based processing. So Getty initially alleged infringement of its database rights, arguing that its curated image library qualified for unique protection. They also asserted that the appearance of its watermark in some of the AI-generated outputs amounted to trademark infringement and misrepresentation. So Stability AI quite obviously denied copying a substantial part of any Getty work and argued that outputs were created by independent users and not by Stability AI itself. It also contended that tangible software models can't be considered infringing articles under UK law. So as the claim progressed, by closing submissions, Getty had abandoned its primary copyright and database claims, instead focusing on the secondary infringement, i.e. that Stability AI were importing or distributing an infringing article and trademark, resulting in the passing off of the market as their own, and with then the infringer benefiting from the goodwill held in that mark. So the shift in the arguments reflected really the evidential difficulty of proving direct copyright within the UK jurisdiction, and I've no doubt that this is something that many claimants will encounter in future cases. So what was the judgment? I mean, in summary, it's a long judgment, but just picking up on some of the key points. It was held that the trademark findings were specific and related to historic infringements. So Getty's broader claim failed as there was no evidence of change in economic behaviour, and the fact that each watermark and image produced by Stable Diffusion AI would be different meant that there was no sustainable case on tarnishment. The judge, who was Justice Joanna Smith DBE, didn't address the passing off claim, and she stated that the claim did not add anything to her findings on the trademark claims. And then in terms of whether the data used to train the AI model itself could be treated as an infringing copy, the judge ruled that this wasn't possible. And just to quote from the judgment, which I thought was interesting, whilst it is true that the model weights are altered during training by exposure to copyright works, by the end of that process, the model itself does not store any of those copyright works. The model weights are not themselves an infringing copy, and they do not store an infringing copy. They are purely the product of the patterns and features which they have learnt over time during the training process. So again, there's question being asked about the interplay between AI and intellectual property, and potential claims, and who has obligations to who in those instances, and say intellectual property and the use of AI and how intellectual property is being infringed is just going to be an area of focus, I think, for the courts and claimants. So just moving very quickly onto the last slide, and this is the last consideration really in respect of problems encountered in litigation. And again, I think it would be remiss not to touch on that, but we just wanted to pick up on potential issues with human rights and data protection, which are being caused by AI, and we wanted to highlight a relevant case, which is that of R. Bridges and Chief Constable of South Wales Police. In the interest of time, we're not going to go over this case in any detail, but the link to the judgment and the main points that it raised are in the slides, and you can peruse those at your own leisure once the slides are circulated. But if anybody does have specific questions about data protection breaches arising out of AI, then please let us know, and we can make an introduction to our colleagues in the commercial team who can cover those points in more detail. But Ross now will pick up on some of the best practice guidance that's available on the use of AI.
Thanks, Joe. So yeah, as we've discussed, AI, the use of AI is growing, but it's also littered with a number of different risks as part of its use. So the Law Society has issued sort of tailored guidance to help solicitors understand how AI can be used responsibly, and how to mitigate the associated risks when using AI. And the most recent guidance was published in October. So what are the key takeaways from that guidance? Well, it's important for solicitors to understand the nature of generative AI. And I quite like this phrasing. And it suggests that generative AI, like, ChatGPT and other large language models, they don't know facts. What they do is they generate text based on patterns in training data. And again, this links to the hallucination point, is that they can produce very convincing but ultimately inaccurate and fabricated content. And again, some of the issues that we've touched on, such as fake case law, fake citations. So it's important legal professionals, when using this type of AI, to treat the outputs as not non-authoritative, and to verify all outputs independently. And this speaks to the solicitor's ethical and professional responsibility. So it states that solicitors remain personally accountable for the work produced by AI. And some of the cases that I talked on earlier, there were suggestions that there were mitigating factors, but that didn't remove from the fact that those who produced those outputs or used AI to produce those outputs were ultimately held responsible for them. So lawyers need to check for accuracy, relevance, and appropriateness. And also, the use of AI must comply with data protection laws, client confidentiality, and lawyers' professional obligations. In terms of risk management and transparency, again, AI tools can produce biased results or hallucinating results. And it's important for firms, and this is what the guidance suggests, that firms have clear policies on how AI should be used, including things such as how lawyers should, what tasks are suitable for using what different types of AI products, and how data should be handled. So finally, in terms of practical use cases and limitations, the guidance suggests that AI can assist with summarizing documents, drafting templates, and administrative tasks, but is not suitable for legal analysis, strategic advice, or final decision making. So it turns out there are still a few things left for us humans to do. But the Law Society does encourage cautious adoption of these technologies. But there remains a role for oversight by us humans. If we move on to the next slide, off the back of those cases that I referenced earlier, the courts and tribunals judiciary has also issued guidance on how AI should be used by legal professionals and their court staff. And this again touches on similar points, so emphasizing the importance of oversight and the responsibility for the output that you produced, even if you use AI. There's a risk of data breaches. Again, that's emphasized in the use of public AI tools, and again, the risk of hallucinations is underscored. But it also provides or references that litigants in person are increasingly using AI. And so there's an emphasis that judges should make inquiries if AI was used in submissions and ensure to confirm the accuracy. And there's reference to judges of being aware of the signs of AI generated content. And there's reference to case citations that might look a bit funny, so they might include sort of American legal references rather than the UK. That's something for judges to be wary of, just in the context of AI being able to produce fake documents. So if we move on to the next slide, Lisa, so just to briefly, very briefly, as we're sort of rapidly running out of time, touch on the fact that the ITO has also published guidance which covers sort of best practice for ensuring data compliance when using AI, and how data protection law should be applied when using AI systems. It's not a statutory code, but it contains recommendations on best practice when using these systems. So if we move on to the next slide, Lisa. Some of the key issues it touches on are making sure, even when using these tools, to sort of comply with core data protection principles. When AI tools are being designed, they should be designed with data protection in mind. So considerations of how that data is stored and processed. And companies need to consider how they can mitigate risks with sort of the introduction of training frameworks and sort of assessing the outcomes of AI tools that you're using. And the ICO themselves have an AI risk toolkit that encourages people to use when using these types of tools. So if I can just hand back over to Joe about what you can do to mitigate use or mitigate the risks and the future of AI.
Thanks, Ross. So yes, just turning now to kind of mitigation tactics and some pointers on how to put yourself and your business in a better position to avoid disputes arising from the use of AI. So we recommend that you instill some pre-deployment risk assessment. So undertake compliance checks with the law and sector-specific regulations when undertaking any legal and ethical reviews. Undertake bias and fairness testing, especially if you're in human resources, credit, consumer credit, or customer-facing AI, and that's what you're using. Just ensuring that those bias and fairnesses aren't having an effect on the output. Undertake vendor due diligence, so checking that your suppliers have got data security certifications and transparency on model training and data handling, and then also just ensure that you've got some contractual safeguards in place, so include warranties on compliance, audit rights and liability for AI failures. It's also really useful to have an internal AI policy. So some of the things that should include, first is just the purpose and scope of the AI, and how that's used. And if you are using more than one AI product, having a separate policy for each of those. The policy should also include responsibilities of using AI and the level of responsibility in each role, guidance on input and output and how to record usage, identifying risks, classifying those risks, and then any approval processes that need to be undertaken, and then just having an overall understanding that the user must maintain human oversight. So AI tools are there to assist; they're not to replace the professional judgment of individuals. You also need to think about protecting confidentiality and privilege in documents and information. So again, ensuring that you've got contractual guarantees on data handling in respect of private AI tools, being very clear and prohibiting colleagues and clients from entering sensitive data into open AI tools such as ChatGPT, as it may be that those documents and information are then used as part of the data gathering outside of the workplace, and then as a result confidentiality may be lost. And also advising clients not to enter legal advice or other information which might be subject to privilege into open AI tools, as again it could be used in the training data, and then privilege of those documents or information is lost as a result. And just lastly, provide regular training and updates, review policies that you have in place on a regular basis, make sure that they're still relevant and still effective for the purposes that you want them, that they are in place for. And so it's just kind of keeping that continual review of the policies you have in place. So just looking forward to AI in litigation and what we see the future to hold, just as we've got a few minutes. So obviously the explosion of AI will inevitably mean that there's a flurry of new laws and regulations. Presently, the legal system just isn't able to keep up with the advancement of AI. And even as we were preparing for this webinar, there were new cases coming to light, new information becoming available, and it does become out of date very quickly. You may also have seen in the news recently that there is now a law firm which is offering to run simple debt recovery matters up to a value of 10,000, so still within the small claims limit, but those matters are being run almost entirely by AI, which quite frankly is a little bit scary, but I think there will be more of that to come in the future. March 2023, the government at the time, Rishi Sunak's government, published its AI regulation white paper, and that set out its pro-innovation approach to AI regulation. Now, that approach sets out 5 principles for regulators to interpret and apply within their own remit. And those principles were safety, security and robustness, appropriate transparency and explainability, fairness, accountability and governance, and then contestability and redress. So at present, the government has postponed creating a single AI specific bill, and it's leaving sector regulators to provide its own guidance on the interpretation of those 5 principles. And obviously Ross has just covered a few of those in the earlier slides. In respect of the judiciary, it's inevitable that they will need to fully embrace AI eventually. And we have seen some glimmers of reliance on technology and AI tools, but the court system in England and Wales is playing catch up with other sectors. Having said that, I mean, there have been some instances where judges have acknowledged the increase in efficiency in using AI and even admitted themselves to using permitted AI tools to draft parts of judgments, although heavily caveating that with the fact that they've verified such output and satisfied themselves that the content was accurate before relying on it. And certainly Sir Geoffrey Voss, back in November 2023, he advocated for end-to-end digital case management in some courts, and some of those features were end-to-end online litigation, automated notices and smart systems, and then the integration of AI for issue identification and resolution guidance. So it remains to be seen really how quickly the judiciary will implement further use of AI tools, but again, it's certainly something that's coming down the line. And one last thing I did just want to touch on before I pass back to Ross to summarise the key takeaways. It's really important to understand the required evidence and standards to ensure that you're compliant cross-border. So, for example, the EU Artificial Intelligence Act, which is being introduced kind of over a 36-month period in different stages from August 24. So the EU Artificial Intelligence Act is the EU's legislation which is designed to regulate the development, deployment and use of AI systems across the EU. And its aims are to ensure AI is safe, transparent and respects fundamental rights, but also fostering innovation of AI. So it's really important for, especially for in-house counsel and business owners to, if you're dealing and working in multiple jurisdictions, you'll need to familiarise yourselves with the regulations in those different jurisdictions, so the jurisdictions where the AI tools are actually being used, but where the AI produced content is ultimately being used as well. So again, we do have colleagues in our commercial team who can assist with any considerations from this point of view, and happy to make any introductions as necessary. So just lastly, passing back to Ross now just to summarise the key takeaways from today's session.
Thanks, Joe. I mean, yeah, of course, we're wary that there's been a lot of information today because it's just a huge topic and it's fast developing. So we hope you found it useful, but a few things to sort of emphasize and to take away if you take away nothing else. So the first point being adopt AI deliberately. So I've said this a number of times, it's verification and oversight, always apply them. AI can help you and it can be incredibly useful, but it should not replace your individual judgment. So treat outputs produced by AI as drafts and not ultimate decisions. Implement and update your policies. So ensure that your organizations have clear current policies governing how AI should be used, including what tools should be used for what, how data should be handled, and how to mitigate risks. Training and supervision. So make sure that your teams are equipped with the appropriate training tools on AI, how AI should be used and what the limits of this use are, and make sure that that use ultimately is supervised to ensure that it complies with the relevant our relevant requirements ultimately. And also be dispute ready. So make sure you maintain logs of AI interactions, keep training records, keep incident protocols. These will ultimately be crucial if your use of AI is challenged in litigation. So that's all we have. We have a minute to spare. I'm not sure if we will have time for you to touch on some of the questions, Joe.
We did have a couple of pre-submitted questions, so thank you to those who took the time to submit them. And we have had a couple of questions come through the Q&A platform whilst the webinar's been running. But what we'll do, just to save time and make sure that we finish by 10 a.m., is collate those questions and answer them when we circulate the slides, so that you do have access to the questions that have been raised and the answers, but yeah, unfortunately we just don't have time to cover them now. But thank you so much everybody for joining. There is in the next slide again the QR code for the participant feedback, so if you could fill that in, we'd be very grateful, and then also the information regarding the remaining webinars in the series that we're running. So that QR code there has all the details. If there's any topics that do take your fancy and you want to sign up, please do. Again, we'll also circulate the details and the sign up links when we distribute the slides after this session. So again, thank you for joining us, and enjoy the rest of your day. Thank you.